So I am Lorraine Bafulco from Vantaggio HR. It is a great pleasure and honor for me to be here today with the folks from Dentons. We're going to be speaking to you about pandemic year 3. Who would have thought we'd be talking about year 3? We all thought it was going to last a few weeks or a few months. And particularly today, even though we're in year 3, there still are a lot of issues for employers to deal with. So we're going to be talking about some of the remote and hybrid work issues that have emerged as a result of our now being 3 years into this global pandemic. If you could advance the slide, please. Here is our agenda for today, a bit of a roadmap. I'm so glad we have that beautiful graphic there because I don't know about the rest of you, but I'm so tired of seeing graphics of coronaviruses. That is something I never want to see in a PowerPoint again. And as I say that, there might be a few of them on my slides and I apologize, but I will be introducing all the speakers. Then I'm going to share with you, John and I are actually going to share with you a little bit about the employment law and HR issues that arise from having remote workers, particularly multi-state workers. Christine, affectionately known as Kiki, is going to be talking about hybrid work and the impact on employers' responsibilities for reasonable accommodation. And then we're going to talk to John, who is our litigator, who's going to give us an exciting update about some recent litigation matters. Can you advance the slide, please? All right, I want to introduce my co-speakers today, John Rhee. Both John and Kiki are with Dentons, who happens to be the largest law firm in the world, which is, very, very cool. They're both with the Honolulu office of Dentons. John is actually a partner in the Honolulu office, and he's a member of the firm's commercial litigation practice. So what does John get to do as part of that? He does a lot of internal or investigations for companies. He helps companies that end up with administrative proceedings before either the Civil Rights Commission or the U.S. EEOC, and he defends clients who end up with unfortunate civil lawsuits in both state and federal court. So busy man. He's the kind of guy you don't want to ever have to talk to after today's webinar, but if you need that help, he's the best. Christine Kiki is also at Dentons Hawaii. She is a senior managing associate in the Honolulu office. She is a member of the, let me get this right, it's the Employment and Labor Law Group, Employment and Labor Practices Group. Kiki does some similar things to what we just mentioned John does, where she helps clients with civil lawsuits, both in federal and state court. She does help with administrative proceedings, Civil Rights Commission and EEOC as well, some government investigations. Kiki also actively counsels employers on HR matters that where employment law has an impact on what's happening at the workplace. And she has a lot of experience in practicing what we call traditional labor law, which is dealing with unionization, NLRB, helping employers counter organization efforts and union grievances. Just want to caution everybody that the NLRB had gotten a little easier in past years and is getting challenging again. And as a reminder, rights under the National Labor Relations Act don't apply just to unionized companies, to non-unionized companies. This is an area of specialty to Kiki, so please reach out to her if you have challenges in that area. And I am Lorraine Bafulco. I am the president, CEO, and principal consultant of Vantaggio HR. We're a human resource consulting and outsourcing company. We have offices on Maui and Honolulu, and we are headquartered primarily in California, but we have offices in a few other states as well. So we try to do a really good job with our clients to help them from needing to talk to Christine and John, but we work as a team effort to try and help companies have the best HR practices and the least amount of risk possible. So if we could advance the slide, please. So here we're gonna have one more slide. I'm gonna speak to you quickly to see. I told you I was gonna have a coronavirus. Note to my office, let's get rid of those ugly virus graphics.
At least it's not like the red one. That I think that's worse.
Not the red one yet. That one really has gotten old. So I want to talk about one of the repercussions of COVID. We sent people home. We were under quarantine order, and people relocated. We've had studies that have shown that a huge number of Americans relocated during the pandemic. 1 in 5 either relocated or knew someone, trending away from big cities for various different reasons. And if we could advance the slide, let's talk about what this means for employers. with 16 million people. If we could go to the next slide, please. 16 million people in the United States, just about, that relocated during 2020. We know from data from the post office that this means that we probably had people move interstate. Statistically, the post office tells us that 1 in 5 moves are out of state. And that means during COVID and the aftermath, we had a whole bunch of people where maybe before we were all one big happy company working in a certain location, and we've woken up and we've recognized that we may have just become a multi-state employer. And it takes one employee being in another state to create challenges for HR. And we're going to talk about where some of those challenge areas are. Today, our focus is going to be talking about people that have quote unquote permanently relocated. If someone has gone for a few weeks to a location and comes back, the implications for that for payroll and HR are quite different. So we're going to talk about that company that allowed people to work remote and now has folks in 2, 3, 4, 45 states. Advance the slide, please. So what happens when you've got somebody working in another state? If I had 5 cents for every client that told me, oh, well, we let such and such go set up shop and work from her home in Florida, we just pretend she's still a Hawaii employee. Doesn't work that way. Once you have somebody working in another state, you have a responsibility as an employer to get registered to do business in that state, because in essence, that person working from home, that is now an extension of your company. It's an office. You need potentially business licenses. You've got to get set up to be able to collect and remit payroll taxes, where Florida was a bad example, but other states that have state taxes, you have to get set up with the Department of Labor. You've got to ensure that that person who's now working in a different location has appropriate work comp coverage. Don't assume that your carrier will cover employees in a different state. I got very surprised when 16 years ago, I opened our first office in Hawaii, and I found out that the work comp cover we had at the time would not cover people in Hawaii. I had to go out and buy a different policy. We have certain states that are monopolistic states, meaning that you can't use your private work comp insurance there. You have to get work comp set up through the state-run program. And then work comp policies differ quite a bit from one state to another about how they work, as far as having networks that need to be utilized, whether people can pick their own doctors, notices that need to be given to folks. Another wrinkle or challenge with having an employee in another state is that we have 5 different states in the country right now that require that you provide temporary disability insurance. Not every state does, and you need to get registered to be able to offer that. Advance, please, for us. Paid family leave, which I hate the way they call it paid family leave, because it's really not a leave of absence at all. It really is more typically a wage replacement benefit, although some of these locations, it does carry some job protection as well. But look at the number of states right now, and this is growing rapidly, where you have the responsibility to be signed up for and pay in to a paid family leave program, which is similar to disability, but it's in the event the employee needs to take time off to care for a family member. Don't let an employee go work in one of these states and not have this set up, because it will create all sorts of problems. And then you'll have to call John, because you'll have a lawsuit on your hands. So typically these programs are funded by a mix of either employee, employer, or a combination of payroll taxes. So again, really integral that if you have somebody working in a different state than where they have been before and where you're domiciled or headquartered, you need to be on top of this. Next slide, please. So payroll, people ask this to me all the time. There's sort of a rule of thumb, and know that to everything we say, there's always some level of exception. But in general, when an employee works in a location, they pay resident taxes where they work. And where they live. And if they commute to another state, for example, where they're working, this happens all the time, like people live in New Jersey, but they work in Manhattan, so they're working in New York. They typically pay non-resident taxes in the state where they work. So if you've got somebody that has moved and is now in a home office in another state, that state where they are living now is where they're needing to pay resident taxes. So there are some states that have no income tax. Some states and locations have reciprocal agreements where you can avoid double taxation of employees. But if you don't have a reciprocal agreement, you might, as the employer, have an obligation to be withholding both resident and non-resident taxes. So it's tricky, and it's something that you really need to, call your attorney, call your CPA, call your payroll company. Although I have to say most payroll companies will tell you that they can do what you tell them, but they probably are not terribly wanting to advise on these matters. But I have seen companies have to go back and retroactively amend previous quarter and year tax filings for this reason. Let somebody move to Georgia, didn't realize we needed to be withholding and paying in taxes. And boy, is that a nightmare for the employer and the employee if you need to go back and fix these things retroactively. Next slide, please. So what are some of the payroll issues that we've had? Like I mentioned before, people living in one state and working another, or now they're working from home. So we've got this new state or duality state. We have seen employees that have taken advantage of this newfound ability that we've as employer figured out how to let people work remote. We've seen employees that roam from state to state. They spend 3 months with this family member in North Dakota, and then 2 months in Hawaii and 3 months in Texas, for all we know. That you need to know from an HR and payroll perspective. And then there's this very real issue that's going to touch on something I think Kiki's going to speak about as well, which is we don't always know as employers these days where our people are. If they are using a VPN to remote in, if they are communicating with us and our clients via Zoom, they could be anywhere in the world for as far as we know. So we're seeing companies that are having to put systems in place to make sure that they get employees to tell them and acknowledge where they are actually working and living. As well as we've seen some IT systems put in place where, for example, your IT department is able to catch the IP address where somebody is working. This does become a concern too, because today we're going to be talking about the challenges of people being remote somewhere else in this country, but boy, does it get even more complicated if the person is outside of the country. And in fact, I've personally seen a number of employers really kind of crack down on that. And because of some and all of the complexities we're going to be talking about today, have said that employees aren't permitted to actually work internationally. Next slide, please. Employee benefits, again, different laws apply depending upon different states. For all of us that have familiarity with Hawaii, we know we have Hawaii prepaid healthcare, but other states vary. If you have an HMO, an employee goes and works in another state, that HMO might not provide any coverage. Some medical provider networks, such as PPOs, might not have participating providers. So you need to make sure you're on top of that. Be working with a good insurance broker who is licensed and can help you in all of those different locations you might have now. Next slide, please. So which state laws apply? This is like the $64,000 question. And again, it's a little bit different from payroll, where it's the place that the person resides that governs where they pay resident tax. But typically, and I'll let Kiki and John weigh in if they want to, but typically it's the location where the employee is physically performing work that's going to determine which laws apply to them. So do not let an employee move to another state and fail to recognize the different paid sick leave laws or state family type leave laws that might apply. Some of the challenges with this are that many laws depend upon headcount, and not all of the laws out there are really clear with us about, do you count everybody in that state? Do you count everybody across the country? What do we do if the law is silent on that matter? So conundrums for state law compliance when you've got multi-state people.
And for Hawaii employers, it's important to think about our employees who are heading off to California to work from there temporarily, realizing that the laws in California tend to be actually even more complicated than in Hawaii. So you're going to need to seek counsel on how those laws need to be applied.
Yeah, and thanks, Kiki, for that, because on the slide you can see there, and I was trying to go fast, but there is an exception to that. It's the state where you work. California actually passed a law a few years ago that said if an employee is visiting California, even for a very brief business trip, California overtime rules apply, where we pay overtime for over 8 hours in a day, in addition to over 40 in a week. So you're right, it can get complex. Don't just presume it all, all status quo. Next slide, please. So I'm not going to read these all off for you. You guys can take a look at them, but there is a plethora of laws regarding wage and hour issues that you have to be careful of, ranging from meal periods to exemptions and how you determine exemptions and tip credits and minimum wage and when you have to pay a final paycheck and do you have to pay vacation out upon termination and just everything you see on the slide there. Very different, very, very different one from one state to the next. And unfortunately, we are now living in a world too, where cities and counties have jumped on the bandwagon and they are passing laws that impact all of these different things as well. Next slide, please. This slide, the next few slides have a ton of information on there. We're not going over all of it. They're in here to be a resource for you. But as of right now, I wanted you to see the number of locations around the country that have different paid sick leave laws. And Hawaii, luckily, is not yet one of them, although I've seen proposed legislation a number of times. My guess is that we will eventually see it in Hawaii. But these are the number of states that mandate that employers provide to some or all of their employees a certain amount of paid sick leave that, of course, every law is different. How it accrues, when you can use it, who's entitled to it, what's the cap on it. Very, very different. It's hard to find a one size fits all. Next slide. Here are the cities and counties, because it wasn't enough that we have all those states. Next slide. And because California is special, we have all of these cities in California that have their own paid sick leave laws. Next slide. And this is another fairly new concept that we're seeing making its way across the country. It's this mandated vacation time, basically. We call it paid sick leave plus. We've got these jurisdictions that you can see. We've got 2 states, a city and a county, where the employer is required to provide paid time off that can be used for sickness or any purpose. This is also something I think we're going to start seeing more and more of, but another beware point if you have employees working out of state. Next slide. The legality of marijuana by states varies very dramatically. Next slide, please. This is a little quick. This is an out-of-date slide, but it gives you just a sense of across the country. States have taken very, very different positions about the legality of medical marijuana, the legality of recreational marijuana, and how much or how little employers' hands are tied with having to accommodate marijuana usage. No law that at the current time that says that somebody can be impaired or utilize marijuana at the workplace, but the ability of employers to test and what they can and cannot do, tremendously different from one location to the next. Next slide. Family medical leave, another slide in here just for informational purposes for you. This is the number of different states that have their own FMLA type of leave. They're all very, very different from FMLA, as well as states that have unique pregnancy disability leave laws. Next slide. This is just a quick reminder of the different ways that all of those state leave laws can differ from FMLA. Believe me, they get very, very different in the reasons to take leave, who's considered a family member, etc. Again, makes having a one policy fit all really challenging. Next slide, please. These really quickly, are all of the different, they're called small necessities leaves. Different types of leaves for volunteers, for elected officials, for bereavement purposes. Every different state has its own unique handful of different leaves that people may also be entitled to that would probably bring with it some job protection. Next slide. Multi-state HR, here are the things you have to worry about. Protected categories, new hire and termination paperwork. I mentioned before, a lot of different wage and hour issues. All of these new pay transparency laws that we're seeing. Employment posters are different. And one of the things where I have seen our clients particularly get in trouble with is non-compete agreements. Having one drafted that was covered and respected the laws in a certain state, and then having an employee being in a different state. And because this gets fairly technical and legalistic, I'm going to pass the baton here to John. John, if you could spend a few minutes talking to everybody about these challenges of multi-state remote workers and non-competes.
Sure thing. Thank you, Lorraine. It's great to collaborate with you. Can we have the next slide, please? Okay, let me start with a hypothetical first, just to kind of shed light on the intersection of non-competes and remote work. Let's suppose you manage a company. It's based in Hawaii. You hire an employee who works remotely in another state. It could be California, it could be Washington State, New York, any other state. And things work out. The employee is a quick learner. Things, in fact, go swimmingly, and the remote employee gains the confidence of clients. And indeed, let's add to the hypothetical, the remote employee helps to grow the client base. And then suddenly the remote work person, the employee gives notice, seeking another opportunity, spends more time with family. The person gives notice and leaves. Lo and behold, in due course, within weeks or a month, you find out that this former remote employee works for a competitor. And let's add to the hypothetical, some of your clients are discussing doing business with that former employee. So you're probably upset, you might be outraged at this so-called disloyal employee.
Mhm.
You're searching for options. You go back to the employment agreement and you find that non-compete provision. So the question is, do you drop the hammer? Are you going to exact justice? Are you going to threaten to file a lawsuit?
I
And the
love that,
answer,
John. You call up your attorney and you say, "Hey, John, can I drop the hammer?"
I haven't experienced those exact words, but man, I'm waiting for it. Um, and the answer is, it depends. And I know that that's the answer of litigators and attorneys that HR managers so love to hear. It depends. Well, it depends on the jurisdiction. And the reason why is that state laws governing non-competes vary greatly. So if we start with California, California is one particular example. If you're looking to enforce an employee non-compete in California, forget about it. It's not going to happen. Uh,
John, even if you say like, well, what if it's restricted to 3 years in a certain geographic area?
Um, it's not going to fly mainly because there's a particular statute, the Business and Professions Code, Section 1660, 16600. Every contract by which anyone is restrained from engaging in a lawful profession, trade, or business of any kind is to that extent void. And for many years now, California courts have construed the statutory provision broadly with respect to employee non-competes. I want to stress here, we're talking about employee non-competes. Non-competes with respect to co-owners or partners in an LLP is different. So we're talking about employee non-competes. Let's suppose the employer says, well, hey, look, I have a choice of law provision or choice of forum, a forum selection clause in this employment agreement, and it says Hawaii. Can't I just contract around that? And unfortunately for the employer, there's a California appellate decision that basically answers no. And in that case, the appellate court held that the strong public policy in California to preserve worker mobility and competition outweighed, in that case, Maryland's public interest in enforcing non-competes. So you can't do that. Very, very hard to enforce a non-compete in California. So let's switch to Hawaii. Hawaii is one of many states that have employed the so-called rule of reason test. And just briefly, because there's a whole body of law on this, it's employee non-competes are permitted as long as they, one, protect a legitimate business interest, and two, are reasonable. And there's that three-factor test. And for the sake of time, I'll let all the attendees just kind of read the slide as opposed to just my going on about a three-factor legal test. But for practical purposes, what's a legitimate business interest? If the employer says, hey, I want to protect myself, I have a legitimate business interest in protecting myself from pesky former employees competing against me, that's not enough. However, if the employer, pardon me, has invested time and resources in training the employee, has disclosed confidential business information, including trade secrets to that employee, then you have a legitimate protectable business interest. And for practical purposes, reasonable in this rule of reason analysis concerns the geographic scope, the time duration of the non-compete. I'll also add, and this is at the bottom of the slide, about 6 years ago, the Hawaii legislature passed a law with respect to non-compete and non-solicitation agreements relating to an employee of a tech business. They're void. By tech business, we're talking about a business that derives the majority of its gross income from sale or license of products or services resulting from its software development or information technology development. So that's a particular instance where the legislature held as a policy, we want to spur entrepreneurial activity, tech startups. We're going to make it easier for that. We don't want the next young Elon Musk to be saddled with a restrictive covenant in Hawaii. Next slide, please. The second part of the answer of it depends is I want you all to keep in mind that in the past 5-6 years, there's definitely a trend. States and localities, cities have passed measures to restrict enforcement of employee non-competes, just as was the case with Hawaii and technology companies. The largest category of state laws prohibiting use of non-competes concerns what we call low-wage employees. Now, if you look at the slide and the bullet points, I've provided examples. The definition of low wage differs per state, and you can just read the slides for those particular definitions. But keep in mind, this is definitely a trend. It's definitely on the radar of the Biden administration. We're looking at more and more restrictions on enforcement of non-competes. Last bullet point, just want to note, in terms of places that pretty much ban the use of employee non-competes, recently the District of Columbia joined California, North Dakota, and Oklahoma in banning non-competes in most circumstances. So back to you, Lorraine.
All right, thank you. Let's go to the next slide. So please make sure you call John or Kiki before you make that decision that your non-compete is going to be okay. So here's just, as a summary for HR, please don't ignore that there are other states. You've got to get senior management at your firm to recognize that this creates an incredible complexity. You need resources both internally in HR. You need employment counsel. You need online resources to go be able to look up multi-state employment law issues. Do not try and take a Hawaii or a California or any state handbook and slap that in front of employees that are in another state, and really think through that there could be some IT and cybersecurity issues related to people working remote as well, regardless of whether they're in another state, just simply working remote. So remote work definitely is causing us to have to change how we're drafting policy, change what we put in our handbooks, change what we put in our employment agreements. And it's a good time to get all those things taken out, dusted off, and updated. Next slide, please. We're going to now switch gears and Kiki's going to talk to us a little bit about the hybrid work and the impact that has on the employer's very important responsibility to consider and provide reasonable accommodations. Kiki?
Thanks, Lorraine. So, now we're going to talk about this reasonable accommodation issue. And I think all of us could use a refresher at this point. Sorry, can you go back to the other slide? Thank you. I think all of us could use a refresher at this point. So many employees have been allowed to work remotely without having to show that they are a qualified individual with a disability, and that the only accommodation that will work for them and not cause an undue hardship to the employer is working remotely. Now, employers are calling employees back to the office, back to the job site, and it's important to remember what the employer's obligations are under disability law in terms of the interactive process and whether or not to grant an accommodation request for 100% or hybrid remote work. And in addition, the EEOC has become much more litigious. We've seen a higher number of cases actually being filed by the EEOC stepping into the shoes of charging parties and suing the employers for those employee charging parties without the employees having to pay for a lawyer. So with the EEOC having reasonable accommodation on their radar, it's important to think about this topic. In addition, a recent study has shown that 74% of US employers have stated they are going to use a plan to implement a permanent hybrid work model. So what does this mean for employees who seek to work remotely now that their employer has recalled the workforce to the office or job site at least part-time on a hybrid basis? Well, that's what we're going to talk about today. And as a side note, employers need to develop policies that are consistently enforced regarding remote work. Even aside from the ADA issue, the disability discrimination issue, even if an employee is not qualified, a qualified individual with a disability, employees could potentially claim that they were treated differently based on other federal or state protected categories if the employer is not consistent in making decisions about who is allowed to work remotely or who is allowed to have a hybrid work schedule. Next slide, please. So accommodation decisions with remote and hybrid work. Under the ADA, an employer needs to provide a reasonable accommodation to an employee or a qualified individual with a disability, as long as the employee's accommodation allows him or her to perform essential job functions and does not cause an undue hardship to the employer, which means significant difficulty or expense. In some cases, this could include safety and health issues as related to the employee requesting the accommodation or other employees. A qualified individual with a disability is an individual who, with or without reasonable accommodation, can perform the essential functions of the job. The employee has to first satisfy the prerequisites of the job and be able to perform the essential functions of the job with or without reasonable accommodation. John is going to discuss later in this presentation issues related to whether on-site job attendance is an essential function of the job.
That's good.
The EEOC has noted that the fact that an employer temporarily excused performance of one or more essential functions when it closed the workplace and enabled employees to telework for the purpose of keeping them safe from COVID does not mean that the employer permanently changed a job's essential functions. So that's good for employers. It also does not mean that remote work is always a feasible accommodation or that it does not pose an undue hardship to allow employees to work remotely. The EEOC has also clarified that employers have no obligation to refrain from restoring duties that they may have temporarily excused an employee from performing during the pandemic. So this analysis is important when you think about what are the essential functions of the job when an employee submits a reasonable accommodation request. Next slide, please. So the COVID pandemic has been hard and unbearable in some ways on people, but it did provide a bunch of excuses for not getting things done. And one of these is that during the main part of the pandemic, the EEOC had been a little bit more flexible with employers delaying on processing reasonable accommodation requests, especially when a large employer suddenly had 1,000 employees submit reasonable accommodation requests, either for disability or religious reasons relating to vaccine mandates. So now, in a few months ago in July, the EEOC has provided updated guidance and has basically said it's no longer okay to delay. There may be some reasons for the excuse as to a delay in processing accommodation requests, but in general, the EEOC expects employers to get back to business with the interactive process. So just to quickly review how to handle a request to work remotely. First, the employer needs to verify that the employee is a qualified individual with a disability. Second, the employer should verify that the employee has a disability covered by the ADA. Some conditions, such as temporary conditions, are not covered by the ADA. Third, the employer should engage in the interactive process, which can be done not only with the employee, but with the employee's healthcare providers. A lot of employers I've seen stop at one interview or filling out a form with the employee saying what their disability is and what kind of accommodation they need. But employers have a right to take it to another level and request actual medical information from the employee's healthcare provider, and can actually send the healthcare provider a list, the job description list, identifying what the essential functions are, and asking the healthcare provider to say, can this employee perform the essential functions with a reasonable accommodation, and what would the healthcare provider recommend? Next slide, please. So mental illness is sort of a trendy issue recently. I think probably since year one of the pandemic, in talking about how the pandemic has affected people in general with regard to their mental health, the isolation of working remotely, but in addition, how employees with pre-existing mental illness exacerbated by the pandemic may be entitled to a reasonable accommodation. So this slide talks about the fact that, although many people have felt significant stress due to COVID, employees with certain pre-existing mental health conditions like anxiety, PTSD, OCD may have more difficulty handling the disruption to daily life that has accompanied the COVID pandemic, and potentially that could occur if they were required to come back to the office or the job site 100% of the time, or even a couple days a week. So just wanted to point out also that the CDC website still says that having mood disorders, including depression and schizophrenia, can make a person more likely to get very sick from COVID. So this is not just that people with mental illness may have more difficulty handling situations relating to the pandemic or return to the job site, but they also are at higher risk for getting very sick from COVID. Next slide, please. Next slide, thank you. So I think a lot of employers have had a question about whether an employee is entitled to a reasonable accommodation if they live, with their 97-year-old grandma who, is on dialysis and just had a lung transplant. So they may not have that exact question, but in general, I think that has been a question that has come up during the pandemic. And under the ADA, an employee does not have a right to get a reasonable or accommodation to avoid exposing a high-risk family member. Next slide, please. So, I already have been talking about reasonable accommodation issues when an employer reopens the workplace. This slide sort of summarizes that and emphasizes that an employer that recalls employees to the work site after having allowed almost everyone to work remotely does not have to automatically grant telework or remote work or hybrid work as a reasonable accommodation to every employee, even those with disabilities who request to continue this arrangement. What needs to happen is if a request comes in for an accommodation, that the employer engages in the interactive process. But it's also important to note that the employer does not have to give in to the employee's request to work remotely if there is another reasonable accommodation available that does not cause an undue hardship to the employer. Next slide, please. And then we just want you to be aware of some ADA remote work request pitfalls. The EEOC is looking closely at requests for reasonable accommodations, in particular with regard to employees infected with COVID-19, employees with conditions that put them at a higher risk for getting COVID, and employees with mental disabilities who have diminished abilities to cope with COVID-19. The EEOC has explicitly stated that COVID-19 itself can be a disability, in particular long COVID, if it substantially limits a major life activity. Next slide. And also on the topic of employee mental health issues associated with coming back to the office, a recent Harvard Business Review article described a survey in which they found that 1 out of every 3 employees said their return to the workplace had a negative impact on their mental health, citing feelings of anxiety, depression, or general distress. And this stress has negative implications for productivity, engagement, retention. We have that whole wave of younger generation just quitting at the drop of a hat. And it could be that coming back to the office is part of the reason for that. So be careful. Mental health issues that arise out of requiring employees to work 100% of the time in the office could lead to an ADA recognized disability, which would then possibly require remote work as an accommodation. And it's on to you, John.
Great, thank you, Kiki. Next slide, please. So I'm going to give a brief summary of some of the more, I guess, salient or noteworthy litigation cases concerning remote work and COVID-19. Just one caveat, I have to stress, litigation is something of a lagging indicator when it comes to trends and issues in the workplace. That's because litigation takes time, it takes years. So the recent court decisions that I'll be discussing to a large extent, concern preliminary issues such as rulings on motions to dismiss. So the court will take all the allegations in the complaint as true and then determine whether these claims are viable and under the federal standard as plausible. Nevertheless, it's really important to know what claims or issues are before the courts so that we can be aware of what issues to be on the lookout for. Next slide. So the first litigation category is whether or not remote work expenses are reimbursable. And again, that depends on the jurisdiction. So just as background, under California Labor Code Section 2802, employers must reimburse employees for all necessary expenses or losses. So this includes reimbursement for internet access and phone bills when used for remote work purposes. Now, is there a federal law analog to California Labor Code Section 2802? No, there's no specific requirement under federal law to reimburse for remote work purposes. But please keep in mind, under the Fair Labor Standards Act, employers are required to reimburse employees if work expenses cause earnings to drop below minimum wage. Next slide. So there is a pending lawsuit in California in federal district court. This concerns Amazon on this specific issue about reimbursement for remote work expenses. The plaintiff, Mr. Williams, is a software development engineer at Amazon. He's seeking reimbursements for these expenses while he was working from home during COVID-19 during the pandemic. And the main issue here is whether Williams's work, whether his expenses were incurred in direct consequence of the discharge of his or her duties or of his or her obedience to the directions of the employer. So, what does this jargon mean? Amazon basically said, hey, it wasn't us, it was Governor Newsom. Amazon claimed that these expenses were the result of government orders, not any direction or directive by Amazon. Now, at this stage of the litigation, the court rejected Amazon's argument and denied its motion to dismiss. So this particular claim under the Labor Code Section 2802 is survived, is still pending. Next slide, please. So some takeaways, at least as to that opinion. What's a key consideration here is the factual context, as well as the expectations of the job. So the plaintiff is alleging here that Amazon expected him to continue to work from home after the stay-at-home orders were imposed. And the court held that the plaintiff plausibly alleges that Amazon had reason to know that Williams incurred these business expenses, even though he did not explicitly request reimbursement. And I'm quoting from a sentence in the opinion, Amazon, a major tech company, surely knew, or at the very least had reason to know, that its software development engineers who worked from home during the pandemic were incurring basic costs related to that work. So again, this is at the motion to dismiss stage. All the factual allegations are assumed to be true. That claim is still pending. And as this case proceeds, one key theme here is that for these employment cases, factual context is really important. The job duties, the expectations of, in this case, the software development engineer. So there will be tons of factual issues to be litigated. I would imagine among these issues is, for this Amazon software development engineer, to what extent was that work from home experience an Amazon-driven directive? And importantly and relatedly, for software development engineers, to what extent was work from home the status quo? In other words, at least in industry-wide, software development engineers, not exactly low-wage earners, they're pretty tech savvy. At least in the industry, they're fairly tech savvy and mobile. So those are factual issues to be hashed out later on in the litigation. Now, the bottom half of the slide, it points more to practical points or practical considerations, separate and apart from legal requirements. From a business perspective, reimbursement of remote work expenses is increasingly common and popular. So I cite two surveys that were published, Paychex and SHRM, and I'm sure there are others that say pretty much the same thing. Benefits most desired by employees include those for remote work expenses. And according to the SHRM survey, 62% of organizations offer subsidy or reimbursement for at-home work. So again, separate and apart from the legal requirements, it seems to be a good business practice to offer this type of benefit. Next slide, please. So the next litigation topic concerns whether or not on-site pre-shift COVID screenings are compensable. We're talking about work that's before the employee clocks in. And the brief answer is yes, if integral and indispensable to the principal activities that an employee is employed to perform. So that's the critical kind of criterion here. Now, I wish I could report to you all that courts across the country have applied the standard so consistently that I can just recite a single rule and a single fact pattern, and that would be it. Unfortunately, that's not the case. So I'm going to try to, as quickly as I can, go over cases where the court said no, and other cases where court said maybe. So there are cases where one case here involving O'Reilly Auto Enterprises. And I need to go into the facts because, as always, facts are so important in these employment cases. So the plaintiff is a non-exempt driver for O'Reilly, and the job duties included loading and transporting automobile parts from distribution centers to stores. And of course, like a lot of employers, COVID implemented a COVID screening requirement as recommended by the CDC. So this was a requirement for work at each shift, and the examination was conducted on O'Reilly's premises. The court granted O'Reilly's motion to dismiss, finding that the pre-shift COVID screenings were not integral and indispensable to the employee's duties. Now, another case involving Walmart in a different federal district court. I'm going to skip the job duties. You can probably figure out the job duties of an hourly worker at Walmart. It's in this slide. The court found that the medical screenings are not integral and indispensable to the principal activities. And as in the case in O'Reilly, this court in the Walmart case granted the motion to dismiss. I'll note that this case is on appeal before the Eighth Circuit Court of Appeals. We'll continue to monitor that case. Next slide. Sorry, one other, while we're going to the next slide, other consideration is that when you look at that critical assessment, basically we're talking about shipping auto parts, driving auto parts, as well as stocking shelves. Is that integral and indispensable to the principal activities of the worker at O'Reilly or Walmart? And in those cases, the court said no. So we're in a different case involving Amazon, the court said maybe. I say maybe because we're still at that preliminary motion to dismiss stage. So with respect to Amazon, the plaintiffs were hourly employees at Amazon fulfillment centers. And again, the duties were scanning, labeling packages, and so on. Relatively the same arguments. Plaintiffs were saying that the COVID screenings were necessary to ensure Amazon workers could perform their work safely. Amazon argued that no, the COVID screening is not an intrinsic element of picking and packaging items. Here, the court sided with the plaintiff, denied Amazon's motion to dismiss, noting that the assessment of whether or not COVID screens are integral and indispensable to principal activities should be made under conditions normally present. And that's a key or a new wrinkle or consideration that I know that the Walmart and the O'Reilly courts did not note. In other words, the COVID pandemic presented an emergency situation. So in referencing the COVID pandemic, the court held that plaintiffs plausibly alleged that COVID screenings were integral and indispensable to the principal activities in the fulfillment centers. Next slide, please. Okay, just quickly, another case where the court said maybe it's compensable. We're talking about a plaintiff at a medical aid at a senior assisted living facility. Similar type arguments. The plaintiff is alleging that this is integral and indispensable. The defendant said, well, no, because the plaintiff had historically performed these duties without the temperature check and symptom questionnaire. The court denied the defendant's motion to dismiss. It is more than plausible that the plaintiff had direct patient contact while administering medications and that COVID-19 screening may have been integral and indispensable. So takeaway here is that factual issues are really important. The greater the risk to employees, to coworkers, to clients, then the more likely that there's a viable claim, a successful claim to have these pre-shift COVID screenings compensable. Next slide, please. Okay, I'm going to quickly just go through this last category here, which is remote work as reasonable accommodation. And Kiki has already spoken to this. Very quickly, prior to the pandemic, most federal courts sided with employers, ruling that ADA reasonable accommodation requests to work from home, ruling in favor of employers, saying that that was not a reasonable accommodation. Please skip to the next slide. The main point here is that the pandemic changed everything. Employers' claims that on-site attendance is an essential function of the job will be subjected to greater scrutiny. So we had this a successful experiment in remote work for many, including or especially white-collar workers. And this is evidence that remote work may be a reasonable accommodation for those with disabilities. There will be increased litigation concerning this topic, reasonable accommodation requests and remote work. Next slide, please. So for the sake of time, I'm going to wrap up with this. I just want to note, this is an ongoing litigation the EEOC filed, Northern District of Georgia. It is something of a bellwether test case. The EEOC claimed filed an ADA claim alleging that the employer discriminated against the employee when it denied her reasonable request for an accommodation and terminated her employment because of her disability. So here's the scenario. She was diagnosed with chronic lung disease and hypertension. Her physician recommended work from home. During the pandemic, at least as to this issue, it was fine because when emergency measures were in effect, Moncrief and her coworkers worked from home 4 days a week. At some point, the defendant required the staff to return back to working on site. She requested an ADA accommodation. She was denied it, and then shortly thereafter, she was terminated. I've checked the docket this morning. There have been no substantive rulings on this case. I took the time to read the fact scenario because this is a common fact scenario. It was all fine and dandy, remote work during the pandemic. At some point, the employer says, hey, come on back to work on site. And then there are the reasonable accommodation requests. I'll leave it at that, and I'll return the mic to Lorraine.
John, just one final comment question for you, because I'm hearing this. Would you agree as an employment specialist and a litigator, the days of employers being able to unilaterally say everyone has to be at the work site are gone?
That's pretty much, yes, I agree. I don't want to complicate things as a litigator. It's so fact specific. Clearly there's a difference between law firms and construction sites, but you are correct, Lorraine.
Yeah, and I'm running into companies that are wanting to go back to that very black and white world, and I think that has gone for good. So it brings up a lot of complicated questions. So I think you all could see that the world has become more complex. I know in the beginning of COVID, we were feeling like we were getting hit with closures and directives from health authority agencies and authorities and PPP loans and FFCRA, and we felt like there was so much our heads were going to explode. And I don't think any of us would have imagined that 3 years later, we're still living in a very complex environment. I mean, the virus maybe isn't killing as many people as it was. Maybe people aren't getting as sick. Maybe many of our businesses have been able to get back to work, but it's definitely a new world that we're operating in with complexities that we probably couldn't have even imagined before. So all of us, myself, John, and Kiki, are here to be resources to all of you. John, you had a comment.
Sorry, just one final comment. In case anyone was wondering, the fact that a company or employer survived the pandemic by allowing and requiring remote work in and of itself is not dispositive. It's not that's not the comparison level. There are certainly legitimate reasons to compel some, most, or all employees back on site. But again, subject to the interactive process, if the requested remote work requested accommodation causes, let's say, shuffling of schedules, siphoning or pushing a lot of the workload onto others, that may constitute an undue burden.
Yeah, I mean, and the part that I talked about was just the complexity of multi-state compliance. That could be just simply a financial operational hardship for firms. Yeah. All right. Well, we have taken up most of the time, all of the time we had allotted. I know we're running just a few minutes over. We certainly would love to answer a couple of questions for those of you that are willing to stay on another couple of minutes. If you have to bolt off, please don't feel bad. We're going to make sure that everyone attended today gets a copy of the slides. Feel free to put some questions in chat. And because we're at the end here, if you have the ability to and want to unmic and ask a question to any one of us right now, please do so.
And can we advance to the last slide, please?
We sure can.
Thanks.
There we go, the thank you slide. So, probably should have said thank you / mahalo, but we were trying to be multi-state, weren't we? Any questions from anyone? We love questions. Anyone have any experiences related to anything we've talked about that you'd like to share with the other folks on the webinar today? And once again, you will be provided when you get the slides with the contact information for all three of us panelists here. We'd be delighted to have you reach out to one or all of us if you've got a question you want to take up with us individually, as opposed to voicing it on air with everyone here today. All right. Well,
Wait, it says the chat is disabled. You can tell people to raise their hand or select.
Okay.
Q&A. Sorry.
Chat's disabled. All right.
I'll look into that right now.
Here we have a question. Could you provide a webinar specific to recruiting in the future?
We sure could.
Yeah, definitely.
Yeah, pop us an email. And I mean, that is such a broad topic. Pop us an email and give us a little bit more information. I know that one of the things with recruiting these days are all of the pay transparency laws and ban the box laws and having to post salaries, and those vary tremendously by location. Those are some of the things that come to mind on that subject, but we'd love your feedback. We'll see if we can't tailor something that would meet what you're looking for.
Yeah, it looks like there was a clarification that it would be multi-state recruiting. So
Yep.
In line with our presentation today.
Yeah, exactly. Be careful. Come January, California passed a law that for employers of 15 or more, we have to put pay ranges in job ads. And California likes being the first state on these things, and it's not this time. There are other states that have passed similar laws prior to this. Multi-state recruiting. Okay, wonderful. All right, well, we're 7 minutes past. We want to be respectful of everybody's time. We know we had scheduled just to go to the top of the hour. I want to thank John and Kiki for inviting me into this Denton's family to present a webinar to both of our client and colleague bases. This has been delightful. We hope you guys enjoyed it. We hope that this is the first of many to come, where we'll join forces and we'll get the HR perspective and the legal perspective that I know is invaluable to all of you trying to make those difficult decisions out there in the workplace. Thank you, everybody, so very, very much for being here today.
Thank you, Lorraine.
You're
Thanks,
very welcome.
Thanks, John.
Take care.